Friends, we are starting now. Today is the 277th Friday group meeting. The topic is Dr. Ambedkar's vision on framing of the Constitution for Free India. Today's speaker is Mr. Devashish Bharuka, one of the topmost young promising senior advocate. And he also addressed our Friday group on 3 different dates. First on 4 September 2024, demystifying a conundrum subclass classification of SC reservation. Second time on 18 February 2024, and third on 27th November 2022. Thank you, Bharuka. So nice of you. And now you initiate lecture on this topic. Please, thank you very much.
Out after discussion with the cabinet mission was to constitute a constituent assembly. Initially, the discussion was that we should have the members elected by way of adult suffrage, but considering that the time was less, what was done was that the provincial committee members were already there and they were asked to select members to be a part of the Constituent Assembly. At that point of time, Dr. Ambedkar was already there as a part of the Bombay committee, and that is how he came to be ultimately a part of the Constituent Assembly. The assembly sat first on the first in it got constituted in July 46, and by December 46 when it sat, Nehru moved the objective resolution, which effectively was in a way a preamble at that point of time as to how there will be the basic and foundational principles of governance of this country. It so happened that by March 47, Dr. Ambedkar was called upon by the All India Scheduled Caste Federation to provide its own constitution and submit it to the assembly. I will come to that particular report later. It's known as the States and Minorities Report, but that reflected a lot on how Dr. Ambedkar was looking in terms of how the India should be governed in the future. In July 47, the constitutional advisor, Mr. B.N. Rao, he was asked to circulate a questionnaire to all the members in order to assess as to what should be the principles, the basic principles. Decisions taken by the assembly and include all matters contained thereto, and to submit to the assembly for consideration the text of draft constitution as revised by the committee. So it was on 29th August that this resolution was taken. Another resolution important what was taken was the actual constitution of the drafting committee, of which Dr. Ambedkar was also a part. He was not made the chairman on that day by the assembly, but the very next day when for the first time there was a sitting of the committee, the drafting committee, unanimously he was appointed as the chairman. So this is how he came about as being the chairman of the drafting committee, which eventually framed the draft constitution which was placed later before the Constituent Assembly for discussions and finalization. It is interesting that in his closing speech in November 49, Dr. Ambedkar expressed his surprise on twofold. First, he said, I was surprised that I was even made a member of this drafting committee. And he said the second surprise came about when he was elected as the chairman. But as history says, that his surprise eventually was a blessing for all of us, because his ideas of how the constitution should be framed, what should be the basic fundamental principles on which our country should be governed, came into light and came into effect through the text which was finalized by the drafting committee, discussed by the assembly, and then finalized finally in 49 as the constitution. So this is the background in which the entire how he came about to become the chairman. I will also discuss towards the end a bit about how the B.N. Rao's contribution was and what Dr. Ambedkar had to say about B.N. Rao. Now to start with, in terms, there are many areas in which we can talk. I have selected a few basic principles which he emphasized on, Dr. Ambedkar emphasized on, and how his own thoughts developed over the time. Now just going back in our history now, we all know 1919 Act was one, the Government of India 1919 Act, by which the Britishers started giving a bit more leverage in terms of giving representation to the Indians in their own governance. In this particular 1919 Act, the entire system was built up in two parts. One was the central government, which would be headed by the Governor General. Most of the major subjects were divided with the central government. Then there were certain subjects which were divided down into the state government, which was at that point of time known as provincial governments. Now the provincial government, it was headed by the governor. Then we had the ministers, which were the committee members, MLC, MLAs, etc. And then there were the ministers. Their two subjects were divided. So the most important of the subjects were reserved with the governor, which obviously would be a Britisher. And then there were the other subjects which were then to be the law to be made by these committees. Now, Dr. Ambedkar became in 1926 a MLC in the Bombay committee. So that is how his really introduction was in terms of seeing as to how a system can be governed. Now, in order to improve the 1919 Act, the Simon Commission came about from England to assess how the working was done and how further we can improve the governance of this country by improving upon the 1919 Act. To assist the Simon Commission, there were different committees which were formed all across the country who really came from these provincial committees under the 1919 Act. Dr. Ambedkar was also part of the Bombay committee, which was to prepare a report to assist the Simon Commission in furthering amending the 1919 Act. Now, it so happened that Dr. Ambedkar completely disagreed with some of the, or rather most of the suggestions made by the Bombay committee, and he came up with his own report. That report, that dissenting report, probably is the first time when the Indian people got to see Dr. Ambedkar's caliber in terms of his constitutional vision for the country and how ultimately if India as and when it will get independent, what should be the basis on which it should be governed. So 1929 Act is one of the, 1929, his dissenting report is something I'll be looking into as we discuss forward individually. The second time when he got to see, write more on this was when he wrote the State and Minorities Report. This came about in 1947, as I just said, when the independence was almost across, Constituent Assembly was already prepared. He was called upon by the All India SC Federation to write a report. Now what he did was, it was not merely a report, it was effectively a kind of a constitution which he prepared, of course focusing more on minority rights. But again, I'll explain in certain areas how he spoke about parliamentary democracy, how he talks about in this report, about federalism, he talks about fundamental rights, he talks about minority rights, he talks about restrictions on fundamental rights, like what we have today in Article 19(1)(g), etc. So this is the second report I will be referring to as we move forward in, while discussing these 4 or 5 of his principles. The third was the letter he wrote to Dr. Rajendra Prasad as the chairman of the drafting committee. So once the drafting committee prepared a draft constitution, he forwarded that under his letter saying this is what needs to be placed before the Constituent Assembly. So that third document, this letter also gives reflections on how he sort of built up this draft constitution, what was on his mind in terms of certain areas. The fourth of the areas which we can look at is his opening speech before the Constituent Assembly when he moved the draft constitution. So there again he explained as to why certain areas, why this draft constitution has been built up, why is it or why not we have not picked up certain principles which should govern the country. So that's the fourth document I believe one should look at when it was the opening speech for the purposes of moving the draft constitution before the assembly. And then the last document I will be relying upon and looking into a bit more is the closing speech when in November 1949 all the discussions were done, who was the last person who had to close the entire discussion, and there he kind of not only sums up many of these principles, his foundational principles, but he also indicates, and that's the last point I'll be raising and sort of indicating as to what really he felt in terms of now that we have this ready document, how is to work and what was the caution. And that probably was the caution which probably seemed to be the most important for the purposes of ensuring that whatever principles he has put into the constitution must flow well, must work well, must implement well. So this is the largest scheme which we'll be looking at. Now to start with, I would look into, one is the parliamentary democracy which he strongly believed in, and with that also the right to vote, etc. Second was in terms of federalism. So federalism, he actually looked into federalism from a slightly different point of view, not the federalism which is adopted by the United States of America. He took a slightly different path and he believed that federalism purely in terms of what the USA is something which cannot be adopted. That is the kind of federalism that B.N. Rao had adopted in his own rough draft of constitution, which ultimately the drafting committee looked into. So he looks into federalism from a slightly different point of view. Then third, I would look into certain rights which he offered, which is the fundamental rights, the limitations, the restrictions, and then also the minority rights which he very closely safeguarded, certain criticisms of minority rights which he looks into in the closing speech. Then of course along with the fundamental rights, the directive principles which he called as the instruments of instructions, because there were certain principles which always the members believe should be a part of the constitution, but they cannot be as fundamental as the fundamental rights, and therefore they put it in part 4 of the constitution as a part of the directive principles. So this is another lot. These are the nature of rights I'll be looking into. And then the fourth smaller part would be, he spoke about the All India services, what he felt about that. Amendment of the constitution is something which he spoke right in the beginning in 1919 report also, and finally till the closing what he believed, why the amendment and the nature of amendment provisions he has incorporated in the constitution. And then the last would be really about the constitutional morality which he speaks about, which today also there has been a lot of discussions on that. But at that point of time there was a discussion by him on constitutional morality and how exactly the constitution can be implemented if there is certain kind of adherence or obedience to the constitution which should be there. So these are the larger areas I'll be looking at. I'll also look at B.N. Rao versus the Ambedkar few principles which came to a drastic change in terms of how Mr. Rao picked up and how Dr. Ambedkar was there. Now to start with, in terms of parliamentary democracy, this is an area which was very close to his heart. And that's why in the States and Minorities report of 1947, this is before when he was even elected to the committee and became the chairman, when he gave this, he called this constitution of his as the Constitution of the United States of India. So in 1947, this first report clearly reflects upon his thought process. In terms of parliamentary procedure, he came up with two specific things. He created his own preamble. The preamble covers rights, equality, etc. But the first of these provisions, he says that there will be a United States of India and the union so formed shall be indissoluble. I'll come to this part again in terms of indestructible, indissoluble, that's part of the federalism. He says, and that with a view. The view is to secure the blessings both of self-government and good government throughout the United States of India to ourselves and to our posterity. So he looks at self-government. He also looks at good government. This is equally important. Self-government, where it says is Swaraj, good government is Suraj. So good governance is also something which he has been constantly emphasizing, and therefore through his writings and speeches, he has been talking about accountability of government, accountability of ministers. In fact, in his initial report, dissenting report, and I will come to that at some point of time, he says that the ministers needs to be accountable and the ministers should answer to a court of law. In 1929 report, when there was a discussion about the amendment of the 1919 Act. So, in 1947, in this report, number one, is very clear that he would want to have a self-government system in the country, and to that extent, why he picked up now the parliamentary form of government rather than the presidential form of government. But before that, let me now just look into what he writes in the letter to Dr. Rajendra Prasad. This is again very interesting. Initially, when the objective resolution was passed by the assembly, the words used were India would be a sovereign independent republic. This is what was adopted by the Constituent Assembly right in the beginning before this committee had been formed. The word sovereign independent republic. He changes that into saying it should be a sovereign democratic republic. So again, to emphasize that democracy has to be a foundational principle for the governance of the country. So it should find a place right in the preamble itself. So instead of saying sovereign independent republic, he shifts it over to sovereign democratic republic, and the justification one was sovereign assumes that or presumes that a country is independent. So we need not have a double. Republic of course should be there. So instead of the word independent, it replaces with the word democratic. So right from the beginning in preamble, we see how his vision starts getting converted into the text of the constitution by shifting the word independent into democratic. And this was one of the primary things he wrote when he wrote to Dr. Rajendra Prasad right in the beginning, saying in the preamble I have made this change and this is the reason why the change has been made. So this is one of the areas in the terms of parliamentary democracy which reflects his vision. Coming forward, when he introduced the constitution before the assembly, he then explained as to why he has picked up the parliamentary form of government. So he attempted to have a clear distinction between presidential and parliament. He said today, and I think probably because of how we came through with the British Raj, how there was no accountability of the government at that point of time to the people of the India. There was no answerability. Therefore, keeping in that point of view, probably felt that accountability of the government is more important than probably its stability. In a presidential form of government in US, the government would be stable, the accountability is less. But in a parliamentary form of government, considering that the people have elected the people to the parliament, the elected representatives to the parliament is constantly accountable to the people. The ministers are accountable to the parliament. And today also we see in terms of question answer session, in terms of being able to update to the parliament on a constant basis, the accountability of the government of the day is higher in a parliamentary system. So clearly in terms of his vision, he wanted accountability and answerability as one of the primary goals of the Indian government in the future. In that context, he clearly indicates, while he was opening and when he was moving the constitution, he talks about this, he discusses the points of differences in each, and he says that though it is a dual polity over here, but he says the American executive is a non-parliamentary executive, which means that it is not dependent for its existence upon a majority in the Congress, while the British system is a parliamentary executive, which means that it is dependent upon a majority in parliament. So therefore, keeping in mind this, he preferred picking up the British parliamentary system rather than shifting over to the presidential system of America. So this is one of the areas, and this is one of the letters and speeches which we find clearly reflects his thought on why we need to have a system of accountability to the parliamentary democracy process. This particular provision then again is reflected, of course, in the constitution. Therefore we have chapter 4, 5 state legislatures and all about the elections, etc., and how the parliament comes into picture. But in his closing speech in 1949, again we see a reflection, because while he was looking into the critics to the constitution, whatever was made, he again looks into this particular form of government and says that though there can be a lot of critiques, parliamentary form of government probably is the one which is most suitable for the purposes of governance. And I think even from the 1919 Act and earlier, by that time, because there were elections which were going on, and we had already entered into a sort of a system where we were comfortable with this election process and parliamentary, therefore that is something what is adopted. But in his closing speech, what he cautioned is something which is very important for us to look into. He said to maintain democracy, we need to maintain not merely in its form but in its actual substance. So his belief was that whatever we had done in terms of civil disobedience, in terms of dhanyas, in terms of satyagrah, in terms of non-cooperation movements, that is something which is beyond the parliamentary system, which is beyond the constitutional. So therefore, whatever was done till for the purposes of fight for the freedom, that is all okay. But in case we have to truly continue now with the parliamentary system, with the constitutional system, and with democracy, if we are trying to maintain, then this is what the words he used. He said, we must abandon the method of civil disobedience, non-cooperation and satyagrah, when there are no way left for constitutional methods for achieving economic and social objectives. There was a great deal of justification for unconstitutional methods, but where constitutional methods are open, there can be no justification for these unconstitutional methods. These methods are nothing but the grammar of anarchy, and the sooner they are abandoned, the better for us. So in his closing speech, while making sure that the parliamentary procedure is adopted fully within the Indian system, he also cautioned that the time has come that we should now shift over completely to constitutional method. So his vision of Indian system of running was never in terms of that we go back to our system which we had adopted for the purpose of freedom struggle. We have a certain system, a defined written system, a text in the constitution, and the remedies provided within the constitution itself should be the one which should be employed. And that is why when I'll come to the system of the judiciary, he emphasized that a court system where remedies are there before the court must be in place independent of the other two wings. Once you have that constitutional method and that system set up, any other system beyond this would be unconstitutional in nature. So this is one of the principles which he quite strongly followed. In fact, connected to this, is where I'm coming back now to the 1929 dissenting report, where this one line in his summary of recommendations, where he said there should be adult franchise. So as early as in 1929, he was clear that each and every person in this country, if subject to whatever the age limit is, he should have an equal right to vote. So one person, one vote should be there all across. All that connected with his thought process, which sort of built it up over the decades and came up from 1929 report to 1947 report to his letter to the Dr. Rajendra Prasad, to his opening speech and the closing speech. All of them run through a common thread saying a parliamentary democracy system is the one which is to be used in India, one. Number two, we should maintain that system through the constitutional methods, and every person in the country should have a say, a right through a vote to be able to say as to who the government would be. So this is the first of the principles which I thought I would discuss. Then in terms of parliamentary democracy, he also looked into good governance, which I have just said, Suraj, to which he also ensured that there should be at least remedies against invasion of fundamental rights. That number one, again in the state and minority reports, though it was more in terms of concentration towards the minority rights, he specifically dealt with, in Article 2, Section 2, remedies against invasion of fundamental rights. And where he talks about Supreme Court and about the authority of legislation and how there will be limitations, etc. So part of the parliamentary democracy he believed was good democracy, good parliamentary procedure, good governance. And to that context, these remedies have to be there. And that is where in the motion to draft he also speaks about the Indian judiciary and how in India, though we have a duality, we have a unitary judiciary. So that as opposed to the American system, we have a dual system here in terms of the government, state government and central government, division of subjects, etc. But in terms of judiciary, because he was very clear that the enforcement of rights in a judiciary should be uniform across the country. For the purposes of that uniformity, it is important that the judiciary should be unitary. And therefore, we have a single state setup right from below the district judiciary to High Court to Supreme Court, or a single step. It is not that to enforce the state laws we have a separate judiciary, and for federal laws or the central laws we have a separate judiciary. Judiciary is unified. So it's a very unique and interesting combination of having a federal structure, but for the purposes of judiciary, you keep it separate and make it a unitary system. That again came about only because he believed there should be an accountable system, and therefore accountability can happen only through the judiciary. So that's another thing which connects along with this judicial system. Now to move on to the second topic on the federalism. Now federalism, again, it's extremely interesting how the entire issue of federalism came about. He said that the form of government is parliamentary. What would be the form of constitution? The form of constitution can be either federal or it can be either unitary. Now from the purposes and the context in which the India was going through and the way it had to, and with the kind of merit, so you have to understand that we had the British India which was there. There were 550 Indian states, all had to be merged together. They all had their aspirations, they all had their complications. They also had their own intentions of whether to join the Indian Union at all or not. So the federation had to be in a manner so that it balances not only the rights and responsibilities, also their aspirations. So therefore, to pick up something like the US system straight away and importing it into India is something which he was not ready for. That's what B.N. Rao had done. He had said this is a federation because he was highly influenced by the American system. Now the American system, how it works is all the states are effectively coming as a part of an agreement, and then the central government is formed. So the substantial autonomy of the states and the power lie more within the states as opposed to the center. Now here what was done was slightly reversed. Here, when we are building up the federation, we said Article 1 would be India would be a union of states. It would not be a federation of states, it would be a union of states, which basically means that the states have already come together. We are a single one nation. This nation cannot be altered at the whims and fancies of a particular state. All the powers in terms of accession or in terms of altering the boundaries of the state falls within the parliament itself, which is the central system. So we gave more power to the central system. Now in this context, if we come back to that state and minorities report, his proposed preamble, which I just read earlier also, what he called was as the United States of India. Now he says that we ordain that provinces and centrally administered areas and the Indian state shall be joined together into a body politic for legislative, executive and administrative purposes under the style the United States of India, and the union so formed shall be indissoluble. So his second vision of India was India is one and it shall always remain one. There is no question of disintegration of the country, and this should be a part of the constitution itself. So the form of the constitution shall be federation, but then it shall continue to be a complete single unit for all purposes. Now for running, for governance purposes, for administrative purposes, for legislative purposes, we would then see what kind of rules we have to build up within the constitution itself so that the country can run as a whole. It was never the intent that country then can be segregated at some point of time and states are run as a whole. So therefore, initially, though the assembly had two committees, Union Constitution Committee and the Provincial Constitution Committee, they all merged into a single constitution saying that we cannot follow the US system, we don't want to follow. It would not be a federation the way US felt, it will be a union in our own terms. Now, how exactly are we to continue in terms of dividing it? So when he wrote this letter to the President of the Assembly along with the draft constitution, he describes the country, says description of India. In Article 1 of the draft, India has been described as a union of states. For uniformity, the committee has thought it desirable to describe units of union in the new constitution as states, etc. And then he says it will be noticed that the committee has used the term union instead of federation. Nothing much turns on the name, but the committee has preferred to follow the language of the preamble to the British North America Act 1867 and considered that there are advantages in describing India as a union, although its constitution may be federal in structure. So quite categorically he is conscious of the fact that though we are saying union, which effectively would be used for a unitary system, he says we are using union for a purpose, but then it is a federal structure, and that's something which needs to have a clarity on. Now to understand further his thoughts on the federal system, while he did indicate that American system is not what we are accepting and that what we have is our own federation system, how he built it up is, one, he again sort of repeats in the motion on draft constitution that it is an indestructible federation, is a union because it is indestructible. So when he wrote to Dr. Rajendra Prasad, he said we are a union but I am calling it a federation. He explains that while he is introducing the constitution before the assembly by saying that the drafting committee wanted to make it clear that although India was to be a federation, the federation was not the result of an agreement by the states as happened in US to join in a federation, and the federation not being the result of an agreement, no state has the right to secede from it. You cannot come out of the system. Once you are a part of India, you are a part of India. And the federation is a union because it is indestructible. So this is something which not only he was very clear about, he categorically informed the assembly on this point. And that is how when we see part 1 of the constitution, article 1, it says union of states, but after that it is the parliament alone which has got the power to maybe add states, not to subtract, but more important to alter the boundaries of the states. So we see in 1966 there has been changes in Punjab Reorganization Act, in 2000 the Bihar Reorganization Act, the Chhattis Reorganization, and then recently Telangana, Andhra Pradesh Reorganization Act. But that's all done by the parliament. So all the power in terms of this federation has been given to the parliament. Now the second point in federation, what he talks about is flexible federation. Now this is extremely important. Normally either the form would be federation or it would be unitary. What he says is it is a flexible federation. So right from beginning he had this mind of emergency powers. That there could be a situation where in order to keep India, the country as a whole union, we might have a situation where the center takes all over the powers by way of the emergency. So that's what he calls as the emerging powers. very interesting that this is reflected even in the 1929 dissenting report, slightly in a different manner. But then he did indicate over there also that there can be emergency powers given to a certain person if that situation so arises. This came about more forcefully in the letter he wrote to the drafting committee, and then finally when he introduced, he said that India can become a unitary system in case there are situations of financial emergency, when there's a situation of a national emergency, or in case there is a state emergency. Of course, initially Mr. Rao's constitution had slightly different version and a limited emergency powers. This over the time was further developed by Dr. Ambedkar while being in the drafting committee as the chairman. And then the final, what came about was really that the center would override the state if the situation so arises. And though there was a strong critique as to why you are giving more power to the center, he says the federation is such that the center definitely has more powers. The center has got the residual powers. In case of emergency situations, he admitted that yes, there is a situation when the state center would tend to override. But the explanation is beautiful. What he says is that the solution because of these problems is there can be no doubt that in the opinion of the vast majority of the people, the residual loyalty of the citizen in an emergency must be to the center and not to the constituent states. For it is only the center who can work for a common end and for the general interest of the country as a whole. So we see the mindset of Dr. Ambedkar to be very clear on one thing, that the country has to remain as a whole. It just cannot break down under any circumstances. And therefore the residual loyalty, the ultimate loyalty of a citizen must be to the center and not to its own state. Though you are living in a certain portion, you are governed by certain laws, but at the end of it, if the situation so arises, then the federation converts into a unitary system and moves forward. So this is something which is extremely unique for India, which clearly was the brainchild of Dr. Ambedkar. So this is the second part in terms of federalism, the flexible federation. The third he looked into clearly was the center and state balance. So he knew in a federation there would be division of powers, there will be division of subjects and working. So for that purpose, right again from the initial report of 1929, he gave certain suggestions about how there has to be division, how, of course at that point of time the center was extremely powerful in the 1919 Act. And provincial government barely had any other subjects in it. So he clearly gave some suggestions about how there should be a balance. But this is something which again he had in mind because he was a part of the committee, he had given the dissenting report. This is a subject again which was very close to his heart. So he knew that this is an area which will be problematic and therefore this needs to be looked into with a very careful hand. So this is again in the letter when he was writing to Dr. Rajendra Prasad, he lays down about how the union and state distribution has been taking place by the drafting committee in the assembly. And there are areas where the parliament can legislate. One is of course the 7th schedule, the 3 lists etc. made, but there were 3 very unique situations which was carved out in the Indian constitution in order to maintain a center-state balance. One, of course the parliament make laws only with respect to union list, state make laws only with respect to state list exclusively, and both can make laws with respect to concurrent list. But considering that a union has to be maintained, a federation has to be maintained, the country has to be maintained as a whole, 3 exceptions were carved out in the constitution. One, in case 2 or more states come to the parliament and say that you please make a law for us, the parliament would have a right to make a law. That's first. Second, in case there are certain areas which are in the national interest and which require law to be made by the parliament rather than the states, then the procedures provided in terms of how from the Rajya Sabha, 2/3 majority one can pass a resolution and thereafter parliament can make a law. So that's again a very interesting second carving. And third, of course, during the emergency, especially state emergency, where the parliament takes over. So these 3 areas, even though while being able to carefully have a balance of state and center in terms of how they would operate, these 3 exceptions I think are beautifully carved out, which again reflects upon Dr. Ambedkar's thought process of how we need to ensure that the union exists and we are not merely a federation as one would think of a US. This is something which again is reflective of his thoughts on this. And then, while closing speech, again this was a strong critique as to there's too much of centralization, and even though you are saying it is a federation, is effectively a unitary system, To that response, he gives something which is extremely interesting. He talks about the essence of federalism. He says federalism is nothing but a partition. You're partitioning the powers, the responsibilities, the subjects into two governments, central and state. The partition would always remain. To what extent is the partition done is a matter of the requirement of the people and the requirement of the time. That does not in any manner dilute the very concept or essence of federation. Federation continues. The residuary powers may go to state, it may go to center. Center may have some point of time areas where it would like to carry forward and take over certain powers of the state. In the concurrent list, state can make laws if the center is not entering. But this is all partitioning of powers, partitioning of subjects, partitioning of the responsibilities towards the people. But the fundamentals of federation still continues. And then he indicates the chief mark of federalism lies in the partition of the legislative and executive authority between center and units by the constitution. This is the principle embodied in our constitution. Now this is very interesting. Then he indicates clearly, center cannot by its own will alter the boundary of that partition. Once it is there in the constitution, you may do a bit of changes here and there, but effectively this partition remains. It's not that the center will be able to completely finish off states and say the entire state list comes into center list. So those safeguards are there clearly, and for the purposes of maintaining federation, this very sort of a center and state balance, very careful balance in order to ensure that there is also tilt towards center for the purposes of maintaining the union. That is what was his mind all through when he spoke about federalism. So this is what gets reflected over, and that's how then we see all the chapters we have of chapter 18, chapter 11, the center-state relations, which talk about Article 254, 256 is very interesting. 256 talks about the executive power, where the center as an executive power can pass directions to the state being an executive power. One. Number two, the state is to ensure that it follows all the laws of the parliament. So though state is a part of this entire union, it has its own partitioned areas to work and to govern. It must at the end of the day ensure that whatever is done by the center is followed within the scheme, because that's the purpose of maintaining the union. So this is the second area, the federalism, which has been looked and quite carefully crafted into our system. The third area, of course, is the nature of rights. One area is the fundamental rights itself and what are the limitations, the restrictions. Second, obviously he focused on minority rights because he himself had the experience of how being a part of the minority committee, what were the problems being faced, and therefore the minority committee rights was close to his heart. And third, the directive principles. So this nature of rights has been embodied within the system of the constitution in these three separate areas. Now, in terms of rights, I think the state and minorities reports reflect clearly his very, very clear ideology and his ideas about how the fundamental rights has to be there. And he has given in Article 2, he called it the proposed constitution of the United States of India. And the proposed Article 2 spoke about fundamental rights of citizens. And I would not go individually, but he looked into the fundamental rights effectively with respect to the present Article 21, 14, 15, 16, 24, then the restrictions under Article 19 provided for over there, then Article 23, forced labor. So he effectively covered everything which probably one would now see in the constitution. Clearly his mind was already in that framework that even before he was called upon to chair or be a part of the drafting committee, in March 47 itself, he had already framed a constitution containing fundamental rights which effectively today be a part of Part 3 today. So all that vision he had in terms of his own experience and his knowledge and his interactions across, we see reflected in the state of minorities. His limitations on the legislature is again an area which he has carefully crafted. For instance, let me read. No state shall make or enforce any law or custom which shall abridge the privileges and immunities of citizens, nor shall any state deprive any person of life, liberty and property. So all three are coming over here. without due process of law. So due process of law is picked up from the American Constitution. That is what it was at that point of time, picked up by him and also by B.N. Rao in the rough draft Constitution. But eventually in discussions it was realized that due process is something which should not be proper for us, and therefore it was substituted by procedure established by law in Article 21. In terms of limitations, he also looks into certain protection against unequal treatment and how the limitations on the legislature should be there, protection against discrimination, and he spoke a lot about the economic, protection against economic exploitation. So he believed in this particular constitution he prepared at that point of time in March 47, that there should be a complete redoing in terms of industries. He believed in socialism, so he says that the industry should go back to the state. Certain key industries should be run by the state. Certain key non-key industries should be part of the state but run by state corporations. Agriculture to be part of state industry. So all those thoughts which we had in mind is clearly reflected in the states and minorities report. He even talks about education. He talks about higher education, how one should ensure that there should be higher education for those who are not fortunate enough to have education at the right time. So all this then, when he wrote this letter to Dr. Rajendra Prasad, he specifically referred to rights and limitations both, because in the criticism what came about a lot was, why is it that the fundamental rights is then coming up with restrictions, and criticism went to the extent of saying that he effectively diluted all the fundamental rights because of all the restrictions you have placed on what you have permitted the state, or rather the parliament, or to make laws. So one he writes about over here, the committee has attempted to make these rights and limitations to which they must necessarily be subject as definite as possible, since the courts may have to pronounce upon them. I'll just come to this further deliberation on this. So he writes this, and he explains this in the motion while he's drafting. Now there is a criticism in terms of saying that the US does not have these restrictions, it only has the rights. Why is it that India is now coming up with restrictions on fundamental rights? So he said, if you see the US portion, whenever there have been law which probably in some way dilutes a fundamental right, one would go to the court saying my right is diluted. The courts through the judicial process have used the theory of police power and then justified those restrictions in larger public interest. So he said that instead of burdening the courts over here in India, since we are coming up with the entire constitution and we are laying down our fundamental rights, we might as well have restrictions where the parliament can make laws, suppose in public interest, to make laws so as to restrict certain fundamental rights. So he says ultimately the form is the same. The substance is the same, we are merely changing the form. Instead of going through the court route, which has been done by US because there is no such restrictions, we might as well learn in the process and incorporate these restrictions in the constitution itself. And thereafter the state can step in, make laws if need be, and then the courts can step in if there are no reasons. So he uses the word reasonable restrictions, not merely restrictions, which means these are justifiable restrictions which has to be answered. Again, going back to the original idea of accountability. That have restrictions, provide give that kind of a power to the parliament to make laws, but those will be justifiable in a court of law, and therefore you balance it out. So not only he offers the fundamental rights, he also says these are not absolute, there are certain justified restrictions which can be looked into. There are three areas also in terms which he looks into over here while looking into fundamental rights in his closing speech. And that is, he says that this democracy would be nothing if there is no social democracy. And for social democracy, he says, one, there should be liberty, second, equality, and third, fraternity. You say, unless all three are there, it would not help us. So even if you have liberty, but no equality amongst people, then in that situation, the words what he uses is that without equality, liberty would produce the supremacy of the few over the many, like tyranny. And equality without liberty would kill individual initiative. So while justifying fundamental rights chapter in the closing speech, he also said, he said merely having fundamental rights part 3 was of no consequence. We need to have all these three, liberty, equality, and fraternity, together being existence and in actual practice actually being operational to be able to give true meaning to the fundamental rights. So that's an area, and then he looks into minority rights, where very interesting, where the Government of India Act 1919, there was this which he had strongly opposed, was communal electorate. Now, communal electorate was one of the principles which the Britishers adopted for the purposes of divide and rule. He strongly opposed. He said there should be reserved seats for the purposes of parliamentary, executive, and all India services. But to permit communal electorate is something which should be abolished completely. So, right in 1929, he had said so. In his report of States and Minorities of 1947, he spoke about superintendent of having a superintendent of minority affairs. He spoke about social boycotting, how it should be a part of the constitution, abolishing of that, safeguarding of STs, protection in Indian states. So all these areas is something which he strongly believed in and incorporated as he moved forward. Since we had Indian states at that point of time, a very interesting provision which he wanted to incorporate in the constitution. I think by the time the constitution came about, there was no requirement. But he said that any Indian states which is now coming up being a part of India, it should be a necessary condition that it actually accepts all the minority protection rights which will be there in the constitution. So he says, but for that we cannot really permit, because that is an equally a part. So he was so strongly, he believed that minority rights are to be protected under any circumstances. And then in the letter to Dr. Rajendra Prasad also, he speaks about safeguard for minorities, and there also he says that although these provisions do not extend to Indian states, in the larger interest of India, the Indian states should adopt similar provisions for the minorities therein.
Bharuka, how much time?
I think I would take slightly more time, because
I think better we'll go for part 2.
yeah, I think we can do that,
I think
because
friends will go for part
Yes.
2 because we have to attend auditorium also.
yes, I'll probably
So
have
we'll go for some other
another half an hour,
as well.
45 minutes. Yeah, I
Yes.
think I would.
So, if anything left, we can
Yes,
continue
I think
that.
we can do that. Yes.
February, somewhere,
Right.
January, maybe.
Yeah.
Thank you very much, Bharuka. So nicely explained everything. In fact, this is a part of Constituent Assembly debates and B.N. Rao's contribution, particularly Dr. Ambedkar's contribution. We have initiated every month one lecture on overall Constituent Assembly members and their contribution. Last time I requested Raja, Justice Raja, he was very kind enough to give this thing. This time I requested Bharuka, thoroughly prepared and all, very nicely explained. One can do PhD further also. So, thank you very much, Bharuka ji.
Pleasure always, sir.
Yeah, sir. I request, Rahul Sharma will give a vote of thanks. Please, Rahul.
Deshu sir has given me the privilege of extending the vote of thanks, and I am deeply grateful for this honor. On behalf of my respected seniors and esteemed colleague, I thank Senior Advocate Devashish Bharuka for his speech on Dr. Ambedkar's vision on framing the Constitution for free India. Sir, it is such a privilege to listen to a stalwart on this subject like this. And sir, when I say that I have immensely added to my knowledge about Constitution, I think I speak for everyone present here. Sir, like you told us about the States and Minority report that Ambedkar ji provided in 1947, and the resolution that he headed as the chairman, he added the resolution to scrutinize the first draft, and his opening speech in the Constituent Assembly, the closing speech on 25th November 1949 also. And sir, you mentioned that the objective resolution had 3 important points like sovereignty, independence and republic. And the core principles of the objective resolution were incorporated into the final preamble of the Constitution. And in a letter to the President of the Constituent Assembly, to Dr. Rajendra Prasad, Dr. Ambedkar ji requested that the word independence should be replaced by the word democratic. And it became the part of the preamble of our Constitution. So like sovereignty, democratic and republic, India. And sir, you have enlightened us with your knowledge, and sir, we thank you And one important point that you mentioned, that in his report in 1929, Ambedkar ji had suggested that universal adult suffrage should be there, which means one person, one vote system should be there, and he advocated for the rights of the minorities. And in his 1947 report, States and Minority Report, and it should not be abridged. Sir, thank you so much for enlightening us. And on behalf of the organizer, I thank everyone present here for your attendance and making this lecture a resounding success. Thank you.
Thank you.
Thank you, Rahul. Thank you very much.
Thank you.
Please.